I have no lemon in the house, which means I can't make hot water with lemon.
Which explains that how you're on time for the show.
Oh, what's your proposed roadmap?
Okay, follow up on the North Carolina redistricting issue. Then we talk for like 10 minutes on the shutdown, and then we do some Supreme Court predictions, and then I go to bed.
I like that. I'm like a big fan of that roadmap.
Don't forget the sidebars. Don't forget the...
Richard likes it because they didn't account for sidebar.
I actually have a sidebar idea.
Oh, good. Okay. North Carolina. So last time we talked about how North Carolina had gotten pipped for doing unconstitutional racial gerrymander that created 10 Republican districts and 3 Democratic districts.
Hold on, AJ. Was it an unconstitutional racial gerrymander, or was it an unconstitutional partisan gerrymander?
In 2011, they did an unconstitutional racial gerrymander. The court pipped them and said, you got to redo your maps. In redoing their maps, they said, fine, we'll redo our maps, but we still want to have 10 Republican districts and 3 Democratic districts. And so that came back up, and the court said that that is an unconstitutional partisan gerrymander, and that the North Carolina would have to redraw their maps in time for the 2018 election. Since then, the Supreme Court has issued a stay, and so North Carolina is not required to redraw their maps in time for the 2018 election, and it seems unlikely that they will have new maps in time for 2018. So that's sad. That's sad for the people of North Carolina. Justice delayed is justice denied.
What was the right thing for the Supreme Court to do here, do you think?
Well, so I think the way Sam Wong put it, and I think this is accurate, is that if the court had not granted a stay, then you would think that the court had in mind that it was pretty likely that the pending Maryland and Wisconsin partisan gerrymandering cases would come down in favor of the proponents of voting rights.
Oh.
And because the North Carolina order was stayed, you should think it is less likely than if no stay had been issued, but it is still possible that Wisconsin and Maryland will lose those 2 cases.
Interesting.
Like, you see what I mean? Like, if the court had said, oh, well, these cases are going to come down against the states, and they're going to come down in time for North Carolina to have to go ahead and implement this order, if that had been the expectation, then there wouldn't have been any point in staying the North Carolina order. On the other hand, if those 2 state cases were less likely, they were less confident about how the court was going to come out, or in the alternative, if they were less confident about how analogous the North Carolina and the Wisconsin cases are, then the stay would be more appropriate. So it's like sad for the people in North Carolina, but like people shouldn't be disheartened.
Well, this is not good, because we all predicted a victory for the voting rights proponents in Gill v. Whitford.
Oh shit, we did?
Yeah.
Oh man, now we've got a stake in this fight, Tom.
Yeah, this is rough.
Oh, I don't like what the court's doing here in potentially proving us wrong. That's, to say the least, not cool.
Anyway, it's like sad, but it's not the saddest thing that's ever happened. The government shut down for a weekend, but then it came back in time for Tuesday.
So wait, hold on. We're recording on a Monday night at 8:41 p.m. My understanding is that the Senate had passed a bill, but the House had yet to pass that same bill. Is that correct?
No, it passed the House 266 to 150.
Okay.
On Monday.
So did Trump sign the said bill?
As of recording, I am not 100% sure whether Trump has signed it.
No, I think he did. No, the shutdown ends tomorrow. Yeah, he did.
Okay, he signed it.
Okay. So no more shutdown, huh?
Yeah, Trump signs bill, shutdown ends. Yeah. This is what the lying New York Times says anyway.
Does anyone know just practically how these work if you're a government employee? So you're not supposed to go into work today because the government had been shut down, right? And presumably you're not going to be paid for the day that you didn't work. But in the bill that gets passed, do they allocate for paying people that one day they missed?
I don't know. I actually don't know the answer to that. The Washington Post article I was reading about this doesn't say whether doesn't say whether often for a longer shutdown, the government will give folks back pay. But considering that it was only a proportion of the federal workforce that was furloughed, and given that it was just 1 day's pay, they may not backdate that, or I don't know. It may be a subsequent bill or whatever. So I don't know exactly what they're going to do about it. I actually was at a wedding over the weekend, and someone that a friend of mine from when I was in graduate school now works on the congressional staff for the House of Representatives, and he was furloughed on Monday. But he'll be back in the office Tuesday. So I'm assuming that he lost a day's pay, which is like sad, but in the end, like somewhat manageable.
Yeah. So do either of you guys kind of know what parts of the government does shut down, what parts of the government doesn't shut down?
All non-essential employees do not come to work. I know that assistant U.S. attorneys who do civil work are non-essential employees.
How do you know that?
Because in my lawsuits against the federal government, they're not allowed to work.
Oh, that's funny.
Does this mean you get default judgments, Tom?
Man, I wish, but the federal government gets 60 days to respond to all lawsuits. As a matter of course, most regular people get 30 days.
Oh wow. Good. See, that's the federal government working for you, my fellow citizens. They've written a set of rules to make it better for us, the taxpayers.
Yeah, you could
Think
say
about
that
it that way, Tom. So what if there's a 60-day shutdown, Tom? What happens then?
Well, I guess I don't know. That's a good question. It's a very good question. Okay. So in real practice, what happens though is that in almost all of the active cases, the U.S. attorneys will move to stay the case pending the shutdown, and courts will generally grant that. So, we didn't have to get there in any of the cases, but that's always a realistic possibility. I think the last shutdown I was involved in too, we didn't get to any stays of any cases because it was such a short shutdown. But I bet it happened a lot more in that the shutdown from the 1990s.
Like, oh, really?
Yeah, because that was a much longer shutdown, right?
Oh, right. Yeah. AJ, what political stuff would you like to talk about as it relates to this shutdown?
So the big constraints that led to the shutdown, the sort of legislative impasse, had been two issues. First was the funding for the Children's Health Insurance Program, sometimes called CHIP. This is an insurance program for children and low-income families. And the other issue was the issue around immigration, in particular what to do about the Dreamers who had been enrolled in the DACA program, which Trump has said he was going to sunset unless Congress came to an arrangement about it by March. So March is rapidly approaching, and the House passed a continuing resolution to fund the government through for about 4 weeks through February. And as part of that bill, they said nothing about how to help out the Dreamers, but they did extend CHIP for 6 months. Then the Democrats in the Senate blocked the passage of that bill, and so the government shut down for 3 days over the weekend and then through Monday. The Senate had said that they wouldn't vote for a continuing resolution unless they got some commitment about what to do for the Dreamers. And ultimately, the deal that was arranged, McConnell would bring a bill to the vote in the Senate before February 8th to deal with immigration, and in particular, how to set up a program to help Dreamers. Then the government would be funded through February 8th, the same day that McConnell pledges as a deadline for bringing some sort of bill to a vote. And then Children's Health Insurance Program, CHIP, is funded for 6 years. So that is what passed the Senate. So Schumer and McConnell, the Democratic and Republican leaders in the Senate, respectively, brokered this deal, and it ended up passing, by some large number of votes in the House. But Nancy Pelosi, the House Democratic leader, said that she thought that Schumer hadn't really struck a particularly good deal. And I actually think they're both right. I mean, I think Schumer was correct to go for this deal, and I think Pelosi was correct to say that it was not a good deal. I think each of them is doing the savvy thing in their respective caucuses.
So that seems like two contradictory statements.
Yeah, my fear, AJ, seems that the Democrats are, whether the leadership is actually united or actually in a state of disunity, it certainly sends a message of disunity. And if I were a Democrat, I'd be concerned that this creates some serious issues. You know what I mean? It creates there's a signal that's being given to the grassroots that you should be mad at Chuck Schumer and you should be fighting him.
You know the old saying,
and I don't know. I don't know that inter-party warfare is good.
but I don't. Democrats have always been a party with a lot of infighting. Like they've never fallen in line like the Republicans have. That's never been their sort of MO. You know, AJ, I still don't understand. Maybe you could explain why you're saying two contradictory things.
Well, so here's the deal. Worst case scenario, right? You know, the Democrats are unsatisfied that Chuck Schumer or that Mitch McConnell has upheld his end of this week's bargain come February when it's time to do another continuing resolution, and the government shuts down again, right? So the worst case scenario, the government is just going to shut down again, and the Democrats will have as much leverage as they had last time, except in this case, they'll have yet more leverage because during the weekend, the Republicans were bludgeoning Democrats by saying that, you know, the Democrats were holding 9 million children hostage, the children that are enrolled in CHIP, that for which the funding had been discontinued, right? So the Republicans said, we got a bill out of the House that funds CHIP for 6 more years, and the Democrats are blocking it. The Democrats are blocking us from funding CHIP. So in February, when it's time to pass another continuing resolution, that will no longer be on the table, right? Democrats will be in exactly the same position they were before, except that they'll have their CHIP funding. So I actually think that Democrats are sort of no worse off than when they started, but in addition to that, they're slightly better off. Now,
yeah, that seems like that seems like a good deal.
So that's why I think Schumer was right to take the deal. Now, why do I think Pelosi is right to say that it's a bad deal? Can you guess?
Why?
I can't.
Because a lot of Democrats are mad about it, right? So a bunch of Democrats the Democrats that are running for re-election in tough states, like Claire McCaskill, Joe Manchin, et cetera, they voted for it. And the Democrats that you think are running for president, Kamala Harris and Bernie Sanders, et cetera, voted against it. So what does that say? It says that there are a lot of folks in the Democratic base who are mad about this, who wanted DACA sooner than later, and, you know, that they're not excited about having to be patient. And for those folks, you know, they feel like there's a Democratic leader that's speaking for them, right? I mean, they have some appreciation that when the fight comes back next month, there'll be someone who's angry about it. So even as they lose faith in Chuck Schumer, at least there's someone in the Democratic leadership who is preaching their message, right? It's Bernie Sanders, Kamala Harris, Kirsten Gillibrand, and Nancy Pelosi. And
yeah, I don't really buy that it's a bad deal on the substance, but I guess I can see, you know, the need for a voice, maybe. I don't know.
So look, when I take a meeting at work, I sit down with my folks beforehand and I tell them, like, which of us is going to be the good cop, which of us is going to be the bad cop in this meeting, right? You know,
AJ, stop giving away the secrets.
But I think, I don't know that Chuck Schumer and Nancy Pelosi have done this intentionally, but I think you can sort of clearly see that is a dynamic that could be playing out here, right? I think you also have to understand the respective position they have in the government, right? So Chuck Schumer was in a position where his opposite, the Republican Senate leader, could offer him a deal, right? And the deal, Mitch McConnell couldn't guarantee that Trump would sign the bill or that Paul Ryan would hold a vote for that bill in the House. But, you know, he got the concessions that he wanted from his direct opposite in the government. On the other hand, you know, Paul Ryan has sort of made it sound like he doesn't really care what Mitch McConnell may promise. And Trump hasn't really said anything either way either. And so in that respect, right, like, you know, Schumer struck a deal with the person who could give him the relevant promises. Now, Nancy Pelosi is in the House, and Paul Ryan doesn't really seem to care about this deal, and so neither should she, right? I'm sure that if Paul Ryan came to her and made similar commitments to what Mitch McConnell had, then she would feel better about the deal. But I think she feels like she needs to be equally as strident as Paul Ryan in the House, whereas Chuck Schumer needs to cut a deal with Mitch McConnell.
Yeah, I guess at the end of the day, you know, what Chuck Schumer has in his hands is probably a pretty a promise that you can trust because there's a backing to that promise. There's a consequences for not following through with that promise, to bring a bill to vote on the Senate floor. But that doesn't get you a law, right? A vote in the Senate floor only gets you a vote in the Senate floor. There's nothing to guarantee that this bill will even see the light of day in the House, is there?
There's nothing to guarantee that. I mean, there are two things that would guarantee that. First of all, public polling shows that about 70% of Americans think that Congress should cut a deal for the Dreamers. The second thing to keep in mind is that the continuing resolution that just passed is only for 3 weeks. So worst case scenario, the Democrats try to negotiate for 3 weeks, and if it doesn't work out, they're right back where they started, right? There's another shutdown, and maybe they get blamed for it, and maybe they don't. But meanwhile, Chip is funded for 6 years.
Mm-hmm. No, yeah, but I agree with you in the taking of the deal. But here's the thing, right? Like, what consequence is there for the House not passing this bill?
Well, I think on that sense, this deal is particularly good, right? Because then the Democrats can they can basically say, listen, we had a deal with the Republicans, right? And the House refuses to pass this bill. The Republicans refuse to pass this bill. The Republicans are shutting down the government. I mean, so 3 weeks from now, I anticipate the Democrats will be making it seem, this is just politics, right? They'll be making it seem like there was a virtual promise from Mitch McConnell, right? That's why I think this is actually a good deal for the Democrats, and a good deal. Probably the best chance that there is for a real compromise on Dreamers to get passed is that, in 3 weeks, Democrats will be spinning this as the Republicans are shutting down the government. Whereas these last 3 days, there was at least some debate as to who was shutting down the government. 3 weeks from now, when they're done talking about how, there was a bipartisan effort to reopen the government, and then now the Republicans refuse to honor their commitments, and the majority leader refuses to, hear the bill. Or, for that matter, even if McConnell does hear the bill and they do vote it out of the Senate, then it's the House's problem, right? And then the Democrats will then blame all the House Republicans for shutting down the government, which will probably be good politics. It'll be especially good politics going into 2018. That's why I think it's such a great deal. I think the only way this thing gets screwed up is if the Democrats are so busy blaming each other over the next 3 weeks that they're not actually unified on their message. And I fear that that's sort of what's happening. Because, I'm already seeing the op-eds, attacking Chuck Schumer, right? As if this is, a real deal, I'm not going to call it civil war in the Democratic Party, but certainly, there's an opinion piece in the New York Times. Schumer sells out the resistance, this is the type of stuff you're going to be seeing over the next 3 weeks.
Yeah. Schumer definitely has a difficult path, right? That will be difficult for Schumer.
Pelosi made it worse.
I don't think Pelosi made it worse. Look, the hashtag resistance doesn't love Nancy Pelosi, right? It's not like the hashtag resistance is taking their cues from Nancy Pelosi, right? She does not represent the left wing of the party the way Liz Warren or Bernie Sanders do. So the idea that Nancy Pelosi is making things harder for Chuck Schumer with respect to the resistance or the left wing of the party, I think is not accurate, right? So what I think Nancy Pelosi is doing is she is cheerleading for her caucus. She has a different set of constituents from Chuck Schumer, and she is doing what she needs to do to best position her caucus in the House. The fact is that the Republicans have a majority of the House. The House works mostly on a simple majority basis, and there's sort of a left-wing edge of the House, which is Nancy Pelosi's caucus, and there's a right-wing edge of the House, and that's the Freedom Caucus. And so Paul Ryan can't pass a bill without one or other of those two factions, right? Paul Ryan can pass a bill with help from moderate Democrats, or he can pass a bill with help from the Freedom Caucus, but he needs one or the other to pass a bill. So Nancy Pelosi has some leverage, but not nearly so much leverage as Schumer, right? Where in the Senate, anything that's subject to the filibuster, anything that's subject to a cloture vote, Schumer has the power to block as long as he can keep, about 3/4 of his caucus together, right? So Schumer has a much stronger hand and is in a much better place to cut a deal. Nancy Pelosi has to keep her caucus energized.
Yeah.
She can afford to give up far few of her members for a bill that she wants to oppose, and, well, a smaller proportion. A larger number of members, but a smaller proportion of her members. And, she's not privy to the deal, right? she doesn't have the commitments from Paul Ryan that Schumer has from Mitch McConnell. So I think they're each playing their respective roles. But I don't think Nancy Pelosi is making life harder for Chuck Schumer.
Well, so I think so. Here's an example, right? This is what it means to energize your base, right? And this is, I think, bad for Democrats. Representative Luis Gutierrez, Democrat of Illinois, said in a statement, "This shows me that when it comes to immigrants, Latinos and their families, Democrats are still not willing to go to the mat."
Like, Rooch, so maybe may I make a meta point about this? Like, sometimes you drop in quotes like that and act as if like they're, the end all be all, right? Like, that's not correct. What I mean is like, you like, it's like a smoking gun, right? But it's not really a smoking gun. People will have differences, right? Particularly in the Democratic Party.
No, I totally agree with you. I guess the point that I'm making is that the Democrats have done like a very, very good job, I would say, over the last year, at least amongst their elected officials, let's call it, if not within the grassroots itself, of being fairly united, right? And I think that's why they've been able to stop as much stuff as they've been able to stop. I mean, I would give 50% credit to Trump and his general incompetence, but the other 50% credit, I think, has to go to the Democrats, and so I guess I just, as somebody who would also like to see a good Dreamer bill pass, I think this sort of like, I think this is sort of potentially troublesome, right? When Democrats energize their base by attacking other Democrats. I mean, I don't know.
Well, so maybe this will be the last word on this. Ezra Klein has an article on Vox. It's a 13-point bulleted list, and it sort of lays out why he thinks that this is a good deal and that the Democrats did the right thing. And I don't think he gets into much detail about whether like Gutierrez or Pelosi are being helpful to Schumer, but I think basically I agree with each of the 13 bullets. So I think probably we'll put that in the show notes. Folks can check the show notes and they can click it, including Ruchit if he ever listens to the show, and maybe tweet at Ruchit.
I was hoping to click it regardless of my listening to the show.
No, you got to listen to the show and you got to click it in the footnotes, in the show notes.
I mean, I go to the website quite often, actually, for the show notes. I love the show notes. I can't speak for our podcast, obviously, but I do love the show notes.
All right, Supreme Court cases.
Sure, we can do that if you want. That's your jam.
Let's do it.
So before we go, we start with predictions. I want to make a point. Last week, we recorded a show, and in that show, I offered the option of doing 2 Supreme Court cases instead of 1, and that was unanimously rejected. And
you too?
Well, not by me, but the two of you. Were the two of you were the voters, right? I wasn't voting.
I suppose.
And so the case that I wanted to do that we didn't get to do was Artis v. District of Columbia, a case about tolling of statute of limitations. And the Supreme Court decided that case today, so we will never be able to predict that. Sad day.
I mean, I don't know what the outcome was. I technically could predict it.
Yeah,
that's true.
Guess.
It would be like, do you guys know what parimutuel gaming is? Do you guys know what that is?
What is that?
So parimutuel gaming is when you bet on, so horse races are a good example. So you go to one of these, so this is legal in Texas, by the way. You go to like a horse racing track, right? Or just like a convenience store. And you bet on races that happened in history, but they don't tell you what the names of the horses are. So you're betting on something that happened in the past, but you have no knowledge about it. So this is like parimutuel betting for Supreme Court cases. It would be like if we picked a bunch of cases from like 3 terms ago and Tom didn't tell us who the plaintiffs or the defendants were, but basically said, A versus B. A is claiming XYZ. B is claiming, ABC. That's what it would be like. So we could do an entire episode on parimutuel Supreme Court case predictions.
But we would remember the facts of the case, so you'd kind of have an idea.
Would I remember the facts of the case? Would AJ remember the facts of the case?
AJ might, I guess. Okay, so real cases. Let's do real cases. Okay, so this case, the first case is Husted v. A. Philip Randolph Institute. And the question presented in this case is under 52 USC 2507. Can Ohio remove folks from the voter rolls by sending them a letter and waiting 2 election cycles? You might have heard about this case. The voters, basically what happens is voters who have not voted in Ohio elections for 2 years or 2 elections are sent notices to confirm their registration. If the state...
And how many years is that, Tom? Like
2
two elections is...
Yeah. 2.
Okay, it is 2 years. Okay.
If the state receives no response from these individuals, and these individuals then do not vote over the course of the next 4 years, then they are removed from the voting rolls. Okay?
So that's 6 years of not being on the voting, or 6 years of not voting.
Voting, yes, exactly. And a letter. So there's this law called the National Voter Registration Act of 1993 that prohibits the removal of the name of any person from a voting roll, and here's the operative language, by reason of that person's failure to vote, right?
Oh.
So the plaintiffs are arguing, oh, look, Ohio is removing people from these voting rolls because they haven't voted in 6 years. And, maybe...
So what's Ohio's argument to that?
Ohio's argument is that, well, no, that, the reason, that's not the only, basically that's not the only reason we're removing them from the voting rolls. We are removing...
There's also this letter issue.
Yeah, exactly. No, that's exactly what they're saying. Look, this is, and this is an interesting case because at base, this is a sort of a what you would think of a mundane statutory interpretation question, right? Because the language in the statute is Ohio removing these people by reason of the person's failure to vote, right? And on one side, people are arguing, yeah, they are, because, look, the fact that they don't vote for 4 years after they get this letter and 2 years before they get this letter is the reason that they're being removed from the rolls, right? The Sixth Circuit below struck down Ohio's rules and basically said, look, voting is sort of what triggers the removal from the rolls. And Ohio, on the other hand, is saying, well, whoa. That's not the only reason we're removing them from the voting rolls. We also sent them a letter, and they didn't respond to that letter. If they had responded to that letter, they could have voted, or they could have not voted for those 2 years, or those 4 years, and still...
Or forever, I suppose.
No, not forever, because then, remember...
So you constantly have to, spend money on the postal service to, respond to these stupid letters.
So what did the court below hold?
The Sixth Circuit struck down the Ohio... rules, holding that the failure to vote is what triggers the removal from the voting rolls.
This is a really important case. I mean,
is there any sort of circuit split, or is there a reason you can guess why the court was interested in granting cert?
No. I think the reason that they were interested in granting cert is a pretty, even though it is a mundane statutory interpretation case, it is, a pretty important issue of voting rights, right? This question could impact, this could be how Republicans do their next round of voting reform, if you will. By sending letters and waiting for them to not vote, right? And so in oral argument, there are all these questions like, well, what if they had sent a certified letter, right? Would that be sufficient? Would that be, would that cover them? Or, what else could they have done in order to make this kosher? So that's where we are.
What was the state's rationale? Why do they say that they need to prune their rolls?
Why do they need to do this? Yeah.
Why?
Yeah, why do they need to do this? What's their...
Okay, so in terms of why they want to do this is because, people die, people move, the state
fraud?
Has I'm sure voter fraud, but, that's what they're... Listen, voter fraud is what you tell your electorate, right? What you tell the Supreme Court is, well, people die, people move, and the state has a legitimate interest in ensuring the integrity of their voting rolls. And that's absolutely true, right? They do have an interest in in securing and making sure those voting rolls are accurate, right? The question is, can they do it, by reason of a person's failure to vote per the statute? And if not, is this particular policy they've enacted by reason of the person's failure to vote?
I mean, for our listeners, it's probably pretty obvious to you, but this is pretty bad, right? This is a state that is trying to, Ohio in this case, is basically trying to make it harder to vote, right? Because, like, just imagine that in order for you to, like, keep, I don't know, keep electricity, okay? Think of some absurd example. In order for you to keep something that you don't really do that often, you had to send a letter, in order to say, hey, no, I'm good. Please let me keep doing that, I can't even think of an example like that absurd. Do you know what I mean? I don't know. I mean, this is really quite dangerous. I hope the court does the right thing here, because otherwise I do fear that. I do fear that, that there will be more and more, especially Republican states, that pass this type of legislation to sort of cleanse their voter rolls. And what that will do is it will basically say, and I think maybe it's worth answering for a moment the sort of retort to all of my arguments, which is that, well, these people aren't voting anyway. What's the big deal? Like, I mean, this is 6 years without voting. What's the big deal?
I mean, yeah, you're right that the individuals aren't voting, but that doesn't mean we should take them. You know what I mean? Like that doesn't mean we should take them off the voting rolls because they're not voting.
I'm ready to predict.
Okay, AJ, what's your prediction?
My prediction is,
and just heads up, Husted is Ohio, and the institute are the folks suing. It's the institute.
My prediction is 7-2 upholding or affirming the court below.
Whoa.
7-2 affirming the court below, striking down the Ohio voter roll policy. And I think that this is not part of my official prediction, but it would not surprise me if one of the concurring opinions says that the Ohio policy fails to pass a rational basis test, let alone complying with the relevant voting statutes.
Whoa. Oh man. I hope AJ's right about this, but today the cynicism has overtaken me. I think it's going to be a 5-4.
5-4 who?
5-4 for Ohio. So reversing the court below. Sadly, I think that's and it may be a 5-4, but there may be a concurring opinion that says that this runs afoul of the 10th Amendment, that the law itself runs afoul of the 10th Amendment.
No way. No, because that chips too much at any of the precedent upholding the Voting Rights Act. Plus, the Constitution specifically says that Congress can pass laws respecting how states run their elections.
Also, Rooch, this statute applies to voters registered to vote in an election for federal office. So, I mean, it's completely within the federal bounds.
Okay. Never mind then. But I'm still sticking with my 5-4. I'm still sticking with my 5-4 uphold, and it'll be a narrow statutory construction saying that, this has not been, this is the reason for the removal of the voters is their refusal to use the postal service every 2 years, I guess.
I'm...
Just write me a letter. Write me a letter. Is all Ohio's saying. Write me a letter, bro.
I'm sort of with Ruchit in the sense that it seems very close and seems very political. So I'm also a 5-4, but I'm 5-4 the other way. I'm 5-4 in favor of the Institute. I think it's a tough case.
Wait. That's what I said.
Yeah.
Yeah. No, you agree with me, Tom.
No, I agree with you substantively, but I agree with Ruchit that it'll be a lot closer than 7-2.
Okay.
Here my reasoning is, it should be a pretty mundane issue of statutory construction. Interpreting this should be judges calling balls and strikes, but I feel that it's very politicized, and so it's going to be a narrow decision either way, and I really don't know which way that political decision might go, but if you just look at the statute, my argument in favor of why the plaintiff should win in this case is the statute says by reason of a person's failure to vote, right? And
everything is triggered by a failure to vote, right? When you think about it, Tom?
But it's even more simplistic than that, right? If I wanted to write a law that let Ohio win, I would have written a law that says by the only reason being the person's failure to vote, right? Or limiting it to the only reason being the person's failure to vote, right? But that's not what this law says. It says by reason of a person's failure to vote, and if you're drawing from tort and causation law, you know that there can be multiple reasons or causes of an event, right? And that type of causation law isn't like any slight contribution, but it's this idea that there can be multiple substantial factors in something happening, right? And so I can see the court interpreting, well, look, it doesn't say the only reason being the person's failure to vote is what triggers the removal, and if it did say that, then Ohio would win. But what it says is just by reason of the person's failure to vote, and so we can say if the person's failure to vote is a substantial factor in causing their removal, then it's a violation of the National Voter Registration Act, and therefore, is not lawful. So that's where I come down on it.
I'm with you, Tom.
But like I said, it's going to be it seems like it's a political decision. So who knows?
This should be a 9-0, dude. This should be a 9-0 for the voters here. You know what I mean? For the Institute. Because it just can't get much clearer than this, Like, what else did Congress mean? Like, was Congress trying to say, well, listen, if there's a letter requirement, it's all good.
Yeah.
You know what I mean? What's next? A law that's like, what's next? Is Texas going to pass a law that removes you if you don't send them a fax? Like, what the hell?
Yeah.
Yeah.
If you haven't voted and you don't fax, then you're off.
Yeah, if you don't send a fax,
Guys, it's 20:09. What's the next one?
Okay. Calm down.
Okay.
All right. So next one is Virginia. So the next two are both criminal cases. This one is Collins v. Virginia, and the issue here is: does the Fourth Amendment's automobile exception permit a police officer without a warrant to enter private property in order to search a vehicle parked a few feet from the house? So a little background. There was a motorcycle.
I love these Fourth Amendment cases. Love them.
There was a motorcycle, that was observed by police as speeding as fast as 140 miles per hour. Using Facebook, officers found a photo of this motorcycle parked in a particular house with a carport. When they arrived at the house, they noticed the motorcycle. There was a motorcycle-looking object under a tarp in the carport of the house. They removed the tarp and they saw the license plate of the motorcycle match the one that they were looking for. The defendant was eventually charged with knowingly possessing stolen property, the motorcycle. But at trial, the defendant wanted to challenge the search of the motorcycle because the search occurred without a warrant in what's known as the home's curtilage. I didn't know what curtilage was before going to law school, but basically curtilage is this It's not a legal idea, but it sure seems like a legal idea these days. This area that's really sort of close to your house that's treated as the home for Fourth Amendment purposes. I like to think of it as the penumbra of the home. It's like sort of this like area surrounding that emanates from the home that's not quite the home, but it is near the home, right? And so under Fourth Amendment jurisprudence, you normally can't search a home or curtilage without a warrant. You need a warrant issued by a neutral magistrate. However, the Fourth Amendment has what's called the automobile exception. And this is the rule that says because the car is an easily movable object, police don't necessarily have time to wait to get a warrant. They can search a car on probable cause alone. So you don't need a warrant to search a car. You just need to have probable cause. You can't do this with a home without some sort of emergency circumstance, right? And so the entire issue in this case is, look, is the home's curtilage, do you need a warrant to search the home's curtilage, which is not within the privacy of the home per se, but for Fourth Amendment purposes, we have treated it like the home. Do you need a warrant for that, or is it more like the automobile exception, because we do have an automobile here, that you don't need a warrant for, and you can just you can rely on probable cause alone. The Virginia Supreme Court below held that even though there was no warrant, the officer had probable cause to search because of the automobile exception.
Okay. AJ, thoughts, questions?
What did the court below hold?
I just literally said the Virginia Supreme Court held that even though there was no warrant, the officer had probable cause to do a search because of the automobile.
Oh, sorry. I didn't realize that was what the Virginia Supreme Court had said. I thought you were talking about one of the parties. Okay. I don't know. I think it's going to be, the court basically lets cops do anything.
No, dude. The court recently the court has been pretty good, man, on some of these Fourth Amendment issues.
Yeah, I think it just depends on sort of the specific issue, right? Like this, I think this is a good case that butts put those two sort of sides of the court and faces each other, because Richard is right. There is a line of cases recently with this Supreme Court upholding Fourth Amendment rights, compared to there are other cases where the Supreme Court hasn't been so bullish on the Fourth Amendment, and I think that those cases where the court has been sort of bullish on the Fourth Amendment, protecting the Fourth Amendment, bolstering it, do involve sort of areas of privacy, like the phone, the inside of the house is a big one, right? But when you're on the road, the court has really not been a booster of the Fourth Amendment. When you're on the road, it's sort of like all bets are off, and it's mostly because people rely on the automobile exception. And so this case is a great case because it pits the automobile exception right up against the privacy of the home.
This is really interesting, actually, Tom. I didn't think about this in the broader lens of, the automobile exception and sort of how it has been sort of broadly used and the court's been okay with it. But this is sort of if the court wanted to, this would be a way to curtail the availability of the automobile exception.
Sure.
Go ahead, Tom.
And to give you an example of how broad how broad the police powers are when you're on the road, there's this thing called a pretextual stop, right? Basically, a police officer following you can decide, you know what, I don't like the color of that guy's skin, but he changed lanes without signaling, so I'm going to pretextually stop him, right? And the court has held, well, we're not going to look at these pretextual stops on the road and determine whether the police officer was actually, what was the real reason why the police officer pulled this individual over, or was it, like a pretextual reason, basically. So that's one one area. The other area is dog sniffs are not considered searches, right? A dog that sniffs and smells drugs is not considered a search for the purpose of the Fourth Amendment. So a police officer can pretextually stop you on the road with his canine unit in the back, right? Pull you over for not changing lanes properly, or not using the left lane only for changing lanes. I mean, there are a million laws that you can break when you're on the road, right? So they can pull you over pretextually, and then they can bring out their canine and do a sniff, and that wouldn't be a search or a violation of the Fourth Amendment.
I think that it's going to be 5-4 in favor of the state.
5-4 Virginia.
I think the court is going to take this opportunity to sort of restrict the availability of the automobile exception, and it's going to do that kind of on Scalia-like grounds, I think, almost, in the sense that it's going to talk about kind of the sanctity of the home and how our founders wouldn't have wanted you to be able to search their horses. You know what I mean? Just because the horse was parked within 5 or 6 feet of the home. I think Gorsuch has become the go-to on some of these Fourth Amendment and privacy cases.
What are you talking about?
Well, he's been asking a lot of good questions.
Has he?
Yeah, he has. Absolutely. No, he has.
No.
Has he written any opinions about it yet?
No.
That I don't know.
I mean, if you want me to rant about the questions Gorsuch asks on because we have another one, I can. But
Gorsuch is such a smart ass in oral arguments, and it's not useful. At least Scalia was funny, but Gorsuch is just he's the guy in law school who raises his hand too much.
Yeah, actually, that's exactly what I was going to say. I was like, it's not a smart ass. It's like, So for example, in a couple of these cases, he's espoused this property view of the Fourth Amendment, which runs into all. I mean, we've discussed this. It runs into all sorts of problems if you think about it for too long. But anyway, what's your prediction?
So yeah, my prediction is that it is going to be a 6-3. Gorsuch is going to write the majority opinion, and in dissent, you are going to have Thomas, Alito, and who's another person that could dissent? No, 7-2. 7-2. Thomas and Alito are the dissenters. Roberts is going to join.
It's going to be weird when Gorsuch raises his hands for Roberts to call on him before reading his opinion from the bench.
Oh, okay.
Tom, what's your prediction?
I'm actually a little bit more bullish on this than I guess either of. Well, Ruchit is.
No, I'm saying 7-2 for the defendant.
I'm 9-0 for Collins.
Whoa, that would be awesome.
Yeah, I mean, I think here's the thing, right? You have it. The curtilage is generally recognized as basically the same as the home, and then you have the tarp on the vehicle, right?
Yeah,
and so they lifted the tarp to see, that the vehicle was the same automobile, right?
Love it.
I think if you had a different scenario and where the tarp wasn't on the vehicle and you could easily see the motorcycle from as a public person walking down the street, I think you might have a different result. But I think because the tarp was on the vehicle,
yeah,
you gotta reverse.
I hope the ruling's broader than that.
Yeah, maybe. We'll see. The last case is another Supreme Court case about the Fourth Amendment. And this one is called Byrd v. United States. And the issue here is, does a driver have a reasonable expectation of privacy in a rental car when he has the renter's permission to drive the car but is not listed as the authorized driver on the rental agreement? So this is another example of how much power the police have on the road. The defendant in this case, Bird, was driving on a highway, and he was pulled over for driving in the left lane instead of using the left lane as a passing-only lane pursuant to state law or federal law. Yeah.
This is like totally a pretextual stop.
Oh, wait. The other reason noted in the oral arguments as to why Bird was pulled over was that he didn't have his hands at 10 and 2.
Is that a law?
No, but the police officer said it seems suspicious. You know?
This is such a, like... I hope there... I mean, I don't know if there are police officers listening to our show, but if you know someone who's a police officer, go ahead and have them listen to this episode, or maybe all 40-some-odd episodes we've done, and then have them tweet at us, because I want to know from a police officer, we'll keep them anonymous, what percentage of the you didn't have your hands at 10 and 2 on the steering wheel is a pretextual stop versus a, man, I was just so concerned for the safety of that vehicle, Tom. You know, I just, and the fact that he was in a lane that was not for passing, but he wasn't passing anybody.
He was just driving.
He was such a danger. He was just driving. This guy just thinks he can drive anywhere he wants, you know?
Okay, so Bird was pulled over, and the officers noted that he was in a rental car. So the officers asked to see his license and rental agreement. When they looked at the rental agreement, they noticed it didn't list him as an authorized driver. In fact, it said drivers are only allowed to drive the rental car with prior written consent. And they asked him, if they could do a search of his car, but they told him, look, we don't need your consent to do this because it's a rental. Bird says he objected, and the officers searched the car anyway, and they found 49 bricks of heroin and a flak jacket.
Oh.
Yeah. The third...
So they were on to something with their 10 and 2.
Well, the only 10 and 2 pullovers that get to the Supreme Court are the ones that have 49 bricks of heroin, right? It's only the criminals that appeal, right?
True, that's right. That's right. And the whole point of the Fourth Amendment is to protect everyone, not just the criminals, right?
Yeah. So the Third Circuit held that Bird had no reasonable expectation of privacy in a rental car because he had no authorization to drive it. The Fifth Circuit, the Fourth Circuit, and the 10 circuits also generally, with some caveats, agree with the Third Circuit on this. The Sixth Circuit it disagrees and holds that there may be some limited circumstances in which you can have a rental car in this scenario and still have a reasonable expectation of privacy. Again, here at oral arguments, Gorsuch did he played with this idea that maybe reasonable expectation of privacy is not the best way to look at privacy or Fourth Amendment, but instead reasonable searches should be done on a property ownership model approach to privacy. But the bigger issue is obviously, whether the search of this individual's rental car without the permission of the driver is a valid search.
I think this is pretty interesting because I think kind of how the court rules on this will have some weird kind of impacts, right? So I can foresee a sharing economy case where, Tom, you're carrying 49 bricks of heroin in your pockets.
Can we not call it the sharing economy?
Sure. Okay.
Is there a less Orwellian word for it?
Yeah, sure. Let's just think about where you're in an Uber, okay? Tom's in an Uber. I want you to picture this, okay, AJ? Tom's in an Uber. He has 49 bricks of heroin on him, okay? And, the Uber driver doesn't have his hands at 10 and 2. And so police officer pulls over the Uber driver and, let's say Tom has put down one of these bricks of heroin, kind of on the baseboards of the car or something like that, right? And
hold on, though, the reason the police officer pulls the Uber driver over is because he was suspicious that my cryptocurrency payment of him was in Ethereum instead of Bitcoin.
That's right. That's right. And, whether or not that's illegal, the 10 and 2 issue holds. You know what I mean? Which is this driver's does not have his hands at 10 and 2. So now, Tom is in the car with this guy's permission, right? But it's not his property. That car is not his property. So what happens in all of these situations? Like, AJ, you're renting an Airbnb and you've got 49 bricks of heroin. You know what I mean?
Well,
and
I mean, at the end of the day, that's one of the reasons why that property ownership model doesn't really work, because you don't have a property interest in a lot of things that you legitimately have a reasonable expectation of privacy. Like you don't expect the police. Yeah, the hotel room is a good example. Even overnight guests. In certain circumstances may have a reasonable expectation of privacy, right? The problem with this line of logic is we're gonna end up one day where the home is sort of the last bastion of privacy, and with all of the technology that we have in our home, you wonder even if that remains true.
And I think maybe I should stop joking about this 49 bricks of heroin thing, right? Because that's not the issue, really. And I shouldn't have been saying that this entire time. I was just trying to be funny. But the issue is more like, let's say I'm leasing my iPhone right now, right? Is that my property? Well, it belongs to Sprint, I think. You know what I mean? Since they leased it to me. What are my...
And there's probably something in your rental agreement, the click wrap agreement that you sign, that says that you're not supposed to use it for legal purposes.
Sure.
There's and what's not to say that like the next click wrap agreement won't say Sprint as the owner of Ruchit's iPhone allows any police officer to search this phone at any time.
Yeah. No, it's a really good point. It's a really good point.
Because the Sprint doesn't have any,
they don't care.
They have no reason to defend your privacy rights.
I think this is another kind of super important case. And I think this concept of like whether or not, I think this one's going to be closer. I think this one's going to, I guess we should move on to the prediction, or at least I should move on to the prediction instead of continuing to philosophize. But what I meant, AJ, about this, like kind of put aside the term, but essentially there's more and more of the economy where you are basically just renting something and you don't actually own it outright. You know what I mean? It's not your property in a technical sense. But so the use of your Fourth Amendment rights is happening more and more where, the sort of part of how much permission you have is fuzzy, and whether you own it or not is outright like you don't own it.
Here's my question. Let's say the government fines for the police. The Supreme Court fines for the police. How would the Supreme Court operationalize that holding, right? So, like, how are police supposed to be trained to identify whether this is a car that the driver either is actually a signatory on the rental agreement or in fact owns outright, versus how is the officer...
I guess they could just ask him.
Well, what if he refuses to answer?
Yeah, they could also look.
Yeah, they could look at the rental agreement.
Because most rental agreements will say who the authorized drivers are. And
this will bring up another whole point of like, what about when the rental agreement's not clear?
Before we move on, like actually game this out, right? So the officer stops you and says, "Who owns this car?" Right? Is that a I mean, I actually don't know the answer. Is that a question cops are allowed to ask during a pretextual stop?
Oh, I'm sure they are.
I mean, they can ask anything they want, right?
No, but what if you don't answer?
Well, you have the right to remain silent.
Right.
Yeah, but then they have the right to like take you to the jailhouse, obviously.
No, I mean there's specific things that they can. I think there are specific things that they can ask that you have to provide, like driver's license and that sort of thing. But like,
yeah. So they need reasonable suspicion to stop you and ask you questions. They need probable cause to arrest you, right? So, I mean, the point I'm getting at is that fighting for the government in this case would seem very difficult to operationalize, right? You would have this very very fact specific inquiry that an officer would have to make in order to determine whether a car could be searched, right? The much easier and the much more the much easier answer that is much more in keeping with the spirit of the Fourth Amendment as a prophylactic is just to say, look, like, you need permission to search cars, right? Like, you don't have the authority to investigate to find out whether this person is a signatory on the rental agreement before searching the car, right? Like, someone's driving a car, you need probable cause to search a car.
Yeah, I agree, but I think, like, AJ, I guess I would say that it would be pretty easy, I think, also for the court to just say, no, this is legal. There's no operationalizing it per se, right? It's just something cops can do, and they'll keep pushing the limit until there's something that they're not allowed to do, right? So it'll just be for a future case to be like, did the cops go too far? You know what I mean? This one's unfortunately, I think, going to be closer. I still think it's going to come out in favor of the defendant. I think it's going to be 5-4. I think Sotomayor is going to write the majority opinion. I think the fifth vote will be Kennedy. And I think the dissent will probably be written by maybe by Gorsuch. And there he'll go and talk about his kind of property-based view.
I'm with Rooch, 5-4 for the defendant.
Me too.
Can I offer a second guess?
No.
Oh, well, I'm sticking with my official guess. This is my unofficial guess. My unofficial guess is 6-3, and Gorsuch writes a concurring opinion where he elucidates his property-based view.
Cool. You can get unofficial credit if that's right.
Okay, cool. I don't want official credit. I definitely don't want official credit.
You know, I think it'll be close too, but I wonder how much of this is sort of like pundit's fallacy. Like, I want,
I'm sure a lot of it is for me.
I want Byrd, the defendant, to win this case because I think that's the right call.
Tom, good cases today, dude.
Yeah, these are good ones.
I mean, I don't know who to give more credit to. You or the Supreme Court for choosing these cases.
Yeah. So shall we move to sidebars?
Yeah.
Son of a bitch.
Rooch, what's your sidebar?
Dude, hold on a second.
Tom, what's your sidebar?
Okay, my sidebar is this AP News article that will be in the show notes about the doctor who helped the United States kill bin Laden and how he's still in Pakistani prison. So if you remember back in the bin Laden raid, there was this doctor in Pakistan who went around, basically giving fake hepatitis with a fake hepatitis vaccination program, trying to get DNA samples from individuals in this area that bin Laden was located in, trying to identify whether this was bin Laden's family that was there or some other people, in helping the United States pinpoint bin Laden's location. He was not extracted from Pakistan or anyway removed, and he was taken by the Pakistani authorities, who did not charge him with anything in connection with bin Laden's operation. He was instead accused under a tribal law, alleging that he aided and facilitated militants in a nearby tribal region. And the reason that he was charged with this tribal law instead of, what he actually did in connection with the bin Laden operation was because if it was filed in the actual court system, there would not be as many limits on the number of appeals. And in tribal court, apparently in Pakistan, the defendant doesn't have to be present when they're trying him. And then there's and his lawyer's arguing, well, look, if he had been tried in the real courts, then all of this information about how Pakistan was sort of not let in on any of the bin Laden raids would come to light, and that would be a national embarrassment for Pakistan. So they're really just doing this as a way to both punish this individual, this doctor, and to not let anyone know about Pakistan's role in that whole raid. Since 2012, he hasn't seen his lawyer, and his wife and children are his only visitors. He is trying to appeal his tribal sentence, but the appeals haven't proceeded. The courts say that the prosecutor is unavailable for the appeal, according to his lawyer, talking to the Associated Press. Yeah, so it's just an interesting article on where this guy is now, after all of this time, and it's a complicated sort of portrait of this individual.
Dude, that's pretty interesting.
Yeah.
And very sad.
Yeah. Well, it's complicated, right? Because like on one hand, yeah, this guy helped capture bin Laden, but from a medical ethics point, right? Like what he did was probably not good, right?
Yeah,
like,
in fact,
for sure.
Pretty bad, right?
Yeah.
Yeah.
And after all that was said and done, he is just rotting away in this Pakistani prison, right? Like he's definitely not from Norway, so he's not coming to the United States, that's for sure.
Poor guy. He only helped us kill bin Laden.
Yeah, well, I mean, definitely the thing that you should do when someone asks you to violate ethics is ask to make sure that it will facilitate an extrajudicial killing.
Was the killing of bin Laden extrajudicial?
Well, I don't know. Was he tried in a U.S. court before they executed him?
I think.
No, he wasn't. No, wait, what? Did I miss?
I think it's beside the point. Maybe we'll update people next week. So, my sidebar. My sidebar is another podcast. Listen to their podcast instead of our podcast. It's called Sawbones. Internet celebrity Justin McElroy and his wife, who I guess is also internet noteworthy, Dr. Cindy McElroy, do a show called Sawbones where they talk about how screwed up medicine used to be. And they did a live show in Seattle, and at that show, being in Seattle, they decided to make their show about coffee. And it's a pretty interesting tour on the history of how coffee has been used and misused in the practice of medicine. So you get to hear about coffee enemas, and
sounds terrible.
What's terrible?
A coffee enema sounds terrible.
Nah, it sounds fine.
Okay.
Yeah.
Okay. Continue.
You should check out the podcast. Anyway, so I mean, there are people in like 2018 who do coffee enemas. It sounds terrible. Richard's right. I was trying to prank him, but I didn't last for very long during my prank.
Yeah, it sounds horrible.
Yeah. I honestly, like, AJ, I don't know what some of the folks on the socialist left are into. So I was just trying to be like, I was trying to be like, it sounds terrible, but you were like, no, it's pretty good. And I was like, okay.
No, really, it sounds terrible. And I mean, if you do it wrong, you can like really hurt yourself.
AJ, that sounded way too much a lesson from experience from having hurt yourself.
No, I mean, I learned that from listening to the podcast. But also, I mean, you can intuit it from the fact that it's a coffee enema. Like, it's an enema that you give yourself with coffee. So, I mean, I think it's one of those things that you could reasonably suspect would really hurt yourself if you don't do it right.
It's interesting, I guess. Ruchit, what's your sidebar?
My sidebar is also another podcast. It's called The World Book Club. It's by the BBC. I meant it to be my sidebar a few weeks ago, but then I forgot about it. So it's basically a podcast where they talk about different books and different themes, and it's really interesting. The episode that I listened to part of, although not in its entirety because I was in the car, was a discussion of Murder on the Orient Express, by Agatha Christie. So that was a very good movie that I really liked, which I also highly recommend to people. But it was interesting.
Is that movie out?
Dude, it came out like months ago.
Oh, I didn't know that.
Yeah, dude, it's really good. It has Kenneth Branagh. And for folks who don't know who Kenneth Branagh is, he's kind of probably the best Shakespearean actor alive. He's a fantastic actor. But so he plays Hercule Poirot, the detective, and it's a really good movie. But this podcast is really cool because they basically do readings from the book in famous like libraries and stuff like that. So in this particular podcast that I'm referring to, this episode, I think they were doing a reading in some like old library in Vienna, and I was like, wow, this is really, really cool. Yeah, so I recommend it.
Did you know that the Murder on the Orient Express has been made into a movie in 1974, 2001, and most recently 2017?
Wow. This particular, I mean, I haven't seen the other ones, but this one was really very good. Like, I thought the acting was exceptional, and I just didn't guess because I hadn't read the book.
Yeah, I don't know what happens either.
Yeah, I'm not going to ruin it for you, Tom, or for any of our listeners, but I'm going to encourage them to go watch this movie, and if you so see fit, it seems like a different type of books podcast from what I was listening to, right? It's not like kind of an interview with the author or anything like that. It's typically like two scholars discussing the book and kind of pointing out interesting things, reading interesting passages from the book. I don't know. It's not like kind of C-SPAN's Afterwards. That's another podcast that I've always liked, or TV show, I guess you could say. That's also a podcast. So I thought it was different. And, you know, if you're after listening to our podcast, you know, you still have some time left in your day because our podcasts have been getting shorter. I don't know if you, our listeners, have noticed that, but if you still have time, you know, this is something else you can do if you're like, I didn't get enough podcast time today.
Beep, 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 beep. Coming in over the wire, I found 2 tweets from 2 people who think that the Schumer deal is good.
Okay, that's good.
Oh, okay.
So Paul Krugman
Cool.
and Matt Fuller. Paul Krugman is a editorial columnist for the New York Times, and Matt Fuller is a political reporter for the Huffington Post. They both think that the Schumer CR deal is good.
I'm hopeful that Paul Krugman is a future guest on our show.
Yeah, Paul Krugman, tweet us if you check out our show notes.
Tweet Ruchit.
Yeah, tweet at Ruchit.
Dude, if Paul, if you tweet at me, I will tweet back. And that's something that I haven't done in a
Ruchit
long
follows
time.
back. That's the Ruchit promise.
Yeah. No, I didn't say I was going to follow you, Paul, to be clear. I said I would tweet back. I don't want AJ to...
No, Ruchit follows back. The Heartland promise is that Ruchit follows back. Well, what do you want in the show?
What was the segment that Ruchit wanted us to do? There was a new segment.
I forgot already.
Oh my
I already
gosh.
forgot. We didn't do it last time, and so like I just totally forgot. Was it about the future? What was it about? I forgot. Hold on a second. Let me look through the transcript, as they say.
You wanted us to talk about long-term thinking.
Oh yeah,
Which
I almost forgot about that.
I think is like pretty nebulous, and you clearly didn't think about it with a long-term perspective.
Well, I think if you guys had been committed to it, I will be committed to this new segment from next episode. If you guys are committed to this segment,
We don't even know what the segment is.
it's on things that we should think long term about. So it's like 10 minutes maybe on something that is long term ish, you know, and that our listeners can be like, okay, that's on the radar. Like that's something that, you know, maybe I could learn more about.
We already have a segment called Sidebars that is extremely vague. We don't need 2 segments where the criteria for inclusion in the segment is vagaries.
I don't know. I mean, I think we could be talking about long term stuff. What do you say, AJ?
Tell you what, Ruch. Here's what I say. We can do this recurring segment when you start like coming to the show with sidebars. I just want to make sure you're able to handle all the segments we already have.
No, I mean, the thing is with the sidebars is a lot of pressure, dude. Like you want me to find something interesting on the internet every single like week. It's just quite a bit, you know what I mean? And then you won't let it be about cryptocurrencies.
I mean, I have more sidebars than we have episodes for. I have in our Google Doc, I have like 10 of these saved up that I haven't had a chance to use yet.
Richard is literally complaining that he has to do work to put on a podcast.
No, dude. I'm just saying this like what percentage of our audience, go ahead and tweet us if you actually, follow up on our sidebars, right? Do you like actually click on the links in our show notes? Do you actually go check this stuff out? I mean,
we had someone tweeted us to complain about Tom's sidebar the other day.
Oh, really?
Yeah.
Oh, I didn't know that.
Well, she liked Tom's sidebar, but she didn't like the way Tom pronounced Iran, which, to be fair, I guess none of us should like the way Tom pronounced Iran.
English is my second language.
Yeah.
Me too, Tom. Me too, dude. Me too. I would be better if your defense, Tom, was that English is your first language.
Yeah.